Hello and welcome to Win Without Law School. This is our special Contempt of Court class. I'm Arizona lawyer Julie Lebenz, and in this class, I'm going to walk you through the ins and outs of pursuing a contempt of court case as well as defending against a contempt of court case. So here is the procedure for contempt of court. Number one, a party with notice of a court order violates the court order. Number two, the non-violating party files a petition for contempt along with a proposed order to appear. It's a particular court form. Third, the court issues the order to appear by setting a hearing, a date and time and location for a hearing on the petition for contempt. Then the petitioning party serves the responding party with the petition in order to appear. And then both parties appear at the contempt hearing, and the petitioning party has the burden to prove the violation of the court order. This is all controlled by Rule 92 of the Arizona Rules of Family Law Procedure. That rule is about civil contempt and sanctions for noncompliance with a court order. So let's go through the various parts of Rule 92. We're going to start with subsection A, which is entitled Applicability. And it explains that in family law, you can pursue civil contempt, and civil contempt is limited to compelling compliance with a court order or compensating a party for losses because of the failure to comply with a court order. That's different from criminal contempt. And criminal contempt, which it applies sanctions to punish or vindicate the authority of the court, that's criminal, and that's not governed by this family law contempt rule. Instead, we're in this civil contempt realm. And so the extent of the relief you can get is just to compel compliance or to compensate for losses related to the contempt. Let's look at Rule 92B. This talks about the petition. So let's focus on that first. Number one, a party begins a civil contempt proceeding by filing a petition that recites the essential facts alleged to be contemptuous. So in other words, the facts that show that the court order was violated. The petition must comply with Rule 92 and Rules 91, B, C, E, and H. So let's look at these rules under 91 as well. So first is Rule 91B, and it explains that the petition for contempt must include at a minimum the date the judgment was entered. So the underlying order that you're looking to enforce, what was the date it was entered? What was the name and the location of the court that entered the judgment? And then as an attachment to your petition, include a copy of the judgment you're seeking to enforce. But if the judgment is in the official court file, then you can just in your petition reference the judgment and incorporate it by that reference. Also, you'll want to include the page numbers and sections, if applicable, of the judgment that contains the provisions you're wishing to enforce and the relief requested. So in other words, show the court the order that you're arguing that the other side violated, and then show the exact provisions that you're saying were violated. So you want to comply with 91B. And then 91C says your petition has to be verified. So you need to swear under oath that what is in your petition for contempt is true and accurate. So Rule 14 of the Arizona Rules of Family Law Procedure has the exact rules for verifying or a petition for contempt. And then Rule 91E, this explains that, and this is kind of redundant, but it just, this explains that a petition that requests a contempt remedy must comply with Rule 91 and Rule 92. So that one's easy to comply with. And then H, When you file your petition for contempt, you have to also submit an order to appear that is substantially in the form set forth in Form 14, Rule 97 of the Arizona Rules of Family Law Procedure. So this is going to be the order to appear for post-judgment cases. All right, now let's look at this question of what relief are you requesting? Because if we go back, we'll see here under 91B5, you need to include what relief you are requesting when you file your petition. So in other words, what do you want the court to do about this violation of the order if you're able to prove the violation? So what relief are you requesting? Well, Rule 92E has some guidance for you about what you can request. And let me back up a little bit. Rule 92E explains that you need to request a certain amount of relief. And here's what's available to you under the rule of contempt. So number 1, incarceration. Number 2, seizure of property. Number 3, attorney's fees, costs, compensatory or coercive fines, parenting time to make up for time missed due to the contemptor. So the contemptor denied you of parenting time, parenting education classes, employment services, and any other coercive sanction or relief permitted by law, provided their order includes a purge provision under subsection F, and we'll talk about that. So remember, under 92A, we're in this realm of civil contempt. So any sort of relief that is ultimately ordered has to be aimed at compelling compliance with the court order or compensating for losses due to the violation. So incarceration is going to be merited in very few cases. It's sometimes used for contempt of court for not paying child support, but if you're in jail, you can't make money to pay child support. So it's a bit of a contradiction. So that's why it's rarely implemented. So even though incarceration is an option under Rule 92E, keep in mind that it's going to be very rare that the court is going to actually order incarceration for a violation of a family law order. Seizure of property, that could be a type of relief granted in a property enforcement case. So if in your divorce, for example, one party was ordered to pay a certain amount to the other party and they didn't, and now the party that's owed money is seeking a contempt sanction, the court could order the seizure of certain property of the debtor to compensate the person who's owed the money. So seizure of property could be a valid type of relief if there's a property dispute, money owed under a divorce decree or something like that. Attorney's fees, costs, and then fines, so some sort of monetary sanction. But if you're going to court on a contempt case and you have an attorney or you've incurred other costs, you're likely going to want more, more relief than just getting your costs compensated. If you're going through all of this hoopla of, putting together your petition, filing it, preparing for a hearing, you're likely wanting some sort of relief beyond just being compensated for attorney's fees and costs. Parenting time can be ordered if you've lost parenting time because the other side violated a parenting time order and took your time. Parent education classes can be ordered, employment services, and any other coercive sanction permitted by law. So remember, it has to be framed so that it's going to compel compliance or compensate for losses due to the violation. But the bottom line here is that you can ask for some sort of relief that's beyond what's listed here, as long as it fits within that framework. The court does want you to indicate what you want the court to do. It doesn't mean the court's going to grant it, but you are going to need to indicate what is the relief you're asking for. And you can't ask for more than one thing on this list. All right, back to Rule 92B. So we talked about the petition. So the petitioning party is going to file the petition plus a proposed order to appear. And then the court is going to issue the order to appear, which is going to contain the court date. Once you get those documents, you need to serve the petition in order to appear on the alleged contemptor. So your opposing party who you're saying violated the order, you need to serve them with a copy of the petition and the proposed order to appear. Now, here are your service options under Rule 90 or Rule 41. You can do an acceptance of service. That means you need to meet with the other side before a notary public, provide them with a copy of your petition and proposed order to appear, and then have them sign the acceptance of service before a notary and then file the acceptance of service with the court. It may be hard to accomplish that. If the other side is represented by a lawyer, you can ask their lawyer to sign the acceptance of service. Another option is certified mail restricted delivery. So you would take a copy of the petition and a copy of the order to appear, mail it to the opposing party, certified mail restricted delivery. And then if you get the green card back and it's signed by the opposing party, then you would file an affidavit of service by certified mail or something similar to that effect. And you would include a copy of the green card, your receipt from the mailing, and you'd file that with the court as proof of service. The third option is to hire a process server. Now, if you're running into problems with any of these three service options, then head over in the Win Without Law School members area, head over to the divorce or custody establishment sections, look at the sections for case initiation and go to the videos about service of process and look at those. And that will give you more information about what to do if you're running into problems with these three options. Also, accessing those materials, you'll find the forms I've referenced here, the acceptance of service form, the certified mail form, a document to give to a process server. So if you're at this service step, I definitely recommend watching the video on service in either the divorce or custody establishment sections. Okay, notice this is just making it clear that the court cannot enter a contempt finding without first giving the other side a chance to be heard. So if you can't show that you properly serve the other side with a copy of the petition in order to appear, then the court's not going to be able to move forward and enter a contempt finding. The court will need to set a new court date and give you another chance to complete service or just dismiss the case and make you refile. So this is just making clear that the other side is entitled to due process before a contempt finding can be entered. All right, so let's just do a quick summary of Rule 92B. To initiate a contempt case, file a petition that identifies the court order that you're saying was violated. Show the other party had notice of that court order. Explain how the other party violated the court order. Name your requested relief for the violation, plus file a proposed order to appear form. So you're going to include all of that in your petition, plus do the order to appear. And then after filing the petition for contempt and the order to appear, the court will issue the order to appear form by setting a court date. Once you get that, the petitioning party then needs to serve the responding party with a copy of the petition for contempt and completed order to appear by acceptance of service, certified mail, or a process server, and file a proof of service with the court. The court cannot move forward with the contempt hearing or find the responding party in contempt unless the petitioning party shows the responding party received proper notice. So got to show service was done. All right, let's move on to Rule 92C. This is just explaining that you have to use the court's order to appear form. This order to appear must specify the date, time, and place of hearing and must contain the following notice using substantially the following language. But just to simplify this, just use Form 14 in Rule 97 of the Arizona Rules of Family Law Procedure. It's called Order to Appear Post-Judgment, and then you will be in compliance with Rule 92C. All right, let's move on to subsection D. This talks about the hearing. At the hearing on the petition, the court must make an express finding whether the alleged contemptor had notice of the petition in order to appear. So the court first has to find that service was completed properly. Then the court must also determine whether the party who filed the petition has established that the court entered a prior order. So first you show that there was a prior order that the petitioning party is alleging is violated. So if you are the party requesting contempt at the contempt hearing, you can present this underlying court order as one of your exhibits. The court has to find that the alleged contemptor had notice of the prior order. You likely can show this on the face of the underlying order because there's generally a mailing certificate on the bottom. If you had a consent decree and the other side signed it, that's clear evidence of notice. If you went to trial and the record shows the other side was present, that can be evidence of notice. If you have text messages between the two of you referencing your underlying order, that can show they have notice of the order you're seeking to enforce, but you'll need to show that. And then you need to show the failure to comply with that order. So presenting testimony and evidence to prove the responding party violated the court order. Okay, and then Rule 92E, the order and sanctions. Keep in mind that if you're being accused of violating the court order, Rule 92E states that you can show that your failure to comply with the court order was not willful. So if you're the responding party and you did in fact violate the court order, then you can potentially argue, so long as it is true, that your violation of the court order was not willful. So number one position, of course, if it is true, is saying I didn't violate the court order. But alternatively, if you did violate it, then you may want to look at, making this argument that your violation was not willful, that you didn't intentionally violate the court order, you didn't realize what you did was a violation, or that wasn't your intent, you didn't understand the terms of the order, something to show this wasn't something where you knew what the terms were and you willfully violated them. So that's a potential defense, again, so long as it's true. Okay, so back to Rule 92E. If the court finds that there was a violation of the court order, then in that finding of contempt, the judge has to recite the facts on which the contempt finding is based, and the court has to indicate what the appropriate sanctions are for obtaining compliance. And this is where the court will consider what the petitioning party is asking for, consider the evidence, and then ultimately order some sort of sanction. All right, and now finally we have Rule 92F. Actually, there might be some more. This may not be the final one, but we're close to the end. This is the purge provision. So if the court orders incarceration, a fine, or any other sanction for failure to comply with a court order, the order must set conditions for the contemptor to purge the contempt based on the contemptor's present ability to comply. So this is all stuff for the court to make findings on and include in the order. But if the court is ordering incarceration, a fine, or any other sanction, then the court has to include in its order a separate affirmative finding that the contemptor has the present ability to comply and the factual basis for that finding. The court may grant a contemptor reasonable time to comply with the purge provisions. Now, if the court orders incarceration but defers incarceration for more than 24 hours to allow a reasonable time to comply, and if there's still a failure to comply within the time provided, the other party may file an affidavit of noncompliance. Upon receipt of the affidavit or on its own, the court may issue a child support or civil arrest warrant. The contemptor may be brought before the court within 24 hours of arrest for a determination of whether the contemptor continues to have the present ability to comply with the purge. Now, this subsection 3 is going to apply in a very limited number of cases, but this is the process if the court orders incarceration but defers it for more than 24 hours. Okay, and then here is Rule 92G. This is, again, a limited rule that's only going to apply in a few cases, but if the court incarcerates the other side, the violating party after a hearing, the court is required to hold a review hearing at least every 35 days while the violating party is incarcerated. So again, this is going to be really rare when the court orders the other side to do jail time and be in jail for this long. Very rare. I've never seen it. I've seen jail ordered a few times, but if it's over child support, it's just, it kind of doesn't make sense, because if you're in jail, you can't work to make money to pay child support. So this incarceration is rare. I'm going through the whole rule and sharing all of this with you, but I don't want anybody to think that they're going to be entitled to incarceration as a remedy and think that's going to happen and be disappointed. It's going to be very rare cases where any sort of incarceration is ordered. All right, we have reached the end. Here is a summary of what we talked about today. So first, there needs to be an underlying court order and an allegation that it's been violated. Then the non-violating parent would file a petition for contempt along with an order to appear. That petition needs to include the underlying order, an explanation of what was violated, and a request for a remedy. The court will set a hearing on the petition, and the court sets the hearing in the order to appear document. Once the petitioning party receives that completed order to appear from the court, then they need to serve the petition in order to appear on the responding party. Once the hearing is started, the petitioning party has the burden of proof at the hearing, and the responding party can argue either that they didn't violate the order, or they could argue that their violation was not willful. So from there, the court hears the evidence and then makes a ruling about whether or not the violation of the order was proven or not, and then if it was, what the sanction should be. All right. Thank you so much for listening to this Contempt of Court course. If you have any questions about Contempt of Court, feel free to bring those to our live Q&A sessions.